Thank you, Governor.
Thank you. And I think I'm the last one, so I'll recognize myself for 5 minutes. I think, Assistant Secretary Newland, that the quantification of how much water a tribe is entitled to is of great interest to me. And I was reading the various cases and law review articles on this just last night on the airplane flying in from Oregon. And it reminded me that there's a difference of opinion, shall we say, in what that quantification should be based upon. If we go back to Arizona versus California, the Supreme Court pointed out the practicably irrigatable acreage approach. Is that still, in your opinion, the measure, the quantification of tribal rights?
Thank you, Mr. Chairman. Well, you've got me beat in terms of having an up-to-date understanding of, the history of this law. It's been a while since I read a law review article. In terms of the quantification, I think the important thing to note here is, I think you've gotten a flavor of already, is that each tribe's circumstance is different, even or often within the same state. When you look at the Tule River Indian Tribe, for example, they're on the slopes of the Sierra Nevada mountains, and irrigable acreage as a standard is going to be a lot different than it would be, say, at Fort Belknap.
So if I may, because we're going to run out of time, I would like to see, perhaps you could put in writing, that standard that you think applies to each one of these, because you're in charge of the various groups doing the negotiations. And so if we look back at the Winters Doctrine, it was based upon the purpose of the reservation to begin with, and that's how it works. So if I'm going to go to all of those who need to assist in funding each of these, the $12 billion it's going to take, I need to be able to call out the standard. So you'll provide it for me?
We can certainly follow up, Mr. Chairman. I just wanted to make the point that it's unique in each case.
It is, but I just want to go back because all of us struggle to find something we can point at to say this is the foundation for the determination of that amount of water that each tribe is entitled to under the Winters Doctrine. So that goes to the purpose, and that goes to irrigatable acreage back in the Arizona versus California case. That's been a while. So I just want to know what's being applied now so that I can share it with my colleagues when they say, hey, Chair Bentz, you're asking for $12 billion. What's the foundation? So you need to help provide it if you would, please.
I'd be happy to do that, Chairman.
Thank you. I want to go to another issue that's of huge importance, and it's the fact that operation and maintenance costs are not supposed to be included in these agreements. At least that's what's called out in the 1990 Bush administration administrative rule that still, as I understand it, applies. So I would like to ask, and I won't have time to ask each one of the witnesses today this question, so I'll pick on Governor Phillips. In your opinion, looking at the proposed settlement, what in it is going to make the tribe enough money to pay for the O&M costs of the new investment? Because what I see happening is new investment, but then not necessarily the money that's necessary to maintain it. So tell me, what in your opinion is going to be used to pay for the O&M costs of whatever it is that you're going to hopefully get in these your settlement agreement?
Thank you for that. Part of the understanding of the system is that we will have the capacity to develop and have businesses come on now that we have a secured domestic system that will offer the uses of that. But secondly, is surface rights will also have the capacity to utilize for subleasing of that water under there. And so those will be the economic.
Yes, and I was going to go to exactly that, the leasing that occurred perhaps just as recently as last year on the Colorado. And thus, but what I'm most interested in, there appears to be there are means of generating income once you have a water right that's been quantified that you can then deal with. But is it built into each of these settlement agreements, this future commitment, if you will, to maintaining the new infrastructure that the United States is going to help pay for? In your opinion, should that be a requirement in each of these settlement agreements?
You're correct on that. A lot of these infrastructures are built for 50 years, and the capacity there is it grows and there's going to be needs to improve and maintain them. And I agree that there should be a mechanism that's offered to fund those opportunities where O&M is required and replacement as these infrastructures get there. But that is the understanding now, is that O&M isn't part of it. And so there's mechanisms, at least in OK Wingate, where we are looking to replace and understand what it's going to cost us into the future. But getting the water and the resources is the first opportunity for us to have those discussions.
Chair recognizes himself for 5 minutes. Mr. Palumbo, I have a question regarding operation and maintenance, but before I get to that, the challenge, I suppose, in all these negotiations is whether or not there's enough water, particularly where so much time has passed since the Winters case, and so many third parties, non-Indian parties, have filed under state water rights frameworks, and now generations have passed. And so in some interesting way, if that's the right word, you have multi-generation non-Indian folk relying upon water rights, and then tribal folks wondering why the federal government hasn't gotten busy and done its job to sort out their Winters rights. So to you, the Bureau of Reclamation, are stuck in the position of trying to help sort this out. So in your opinion, as you look at these various settlement agreements, is there enough water? And I know it's a broad question, and there's 12 agreements. There's lots of agreements. Give me your general take on it.
Thank you, Chairman Bentz. Fundamentally, the answer is yes. As part of the settlement process, there's 3 distinct teams that are established: an assessment team, a negotiation team, and an implementation team. Those earlier teams, part of the responsibilities they have is to determine if there is enough water to meet the demands of the settlement that might go into negotiation. There's studies that are conducted by the Bureau of Reclamation as well as USGS and other scientific agencies to determine that enough water is available. Also, as part of the settlement process in the negotiation, should lower priority water that might be at risk of not being available at any certain time, it's incumbent upon the United States to communicate that clearly as a good negotiator and in good faith that there is some water that might be of lower priority, that might not be available in certain years, and that's part of the negotiation process. But fundamentally, assessing if that water is available is incumbent upon us, and yes, we do that, and yes, I am comfortable with the 12 settlements in front of us here this morning and afternoon that it's available.
Maybe another way of putting it is to say that when it's not available, that money is used to paper over the shortage. Is that a correct statement?
Can you repeat that? I'm sorry.
Maybe another way of saying it, if their water is not available, money is used, United States money is used to paper over the shortage. Is that a correct statement?
I would say as part of the negotiation, if there were low priority water part of the settlement, that some consideration for lower priority water versus higher priority.
So what I'm doing is giving you an opening to say, as water diminishes, because that appears to be the case, as it becomes drier, the cost of these settlements goes up. That's where I'm really going with this question.
Correct.
Is that true?
That is true. When water becomes more scarce, the dollar per acre foot, so to speak, goes up for capital and the O&M and the whole delivered project.
Right. And so it's one of the reasons that we should be moving forward with these agreements is that they become more expensive the longer we wait. Is that a correct statement?
That's a correct statement for a number of reasons. The one you identified.
Listen, other than the ever-increasing cost of infrastructure, what else? Less water. That's where I'm really going with this.
Yeah, as the climate changes, aridification progresses, there's less water available.
Well, how about an overestimation of how much water there actually was, for example, the Colorado? Now, all of a sudden, we suddenly realize it's not there. Does that mean that the cost to the government, is the government going to be picking up the cost of that miscalculation somewhere inside these agreements?
Yes, fundamentally, it's a cost of negotiating now based on what we believed 100 years ago might be available, for example, in the Colorado River. It's not materializing, so the need to work with a smaller amount of water, it just inherently from a supply and demand
Let's hop
perspective.
ahead. Let's hop ahead. Forgive me for cutting you off. Another question for you. The O&M costs that go with the infrastructure that's going to be contemplated and ultimately constructed, do you, as an agency, try to figure out how they're going to be paid? Because the idea is that they would not be included in the money generated by the federal government handed to any one of the tribal parts of these agreements.
Yes, as part of many water rights settlements, economic development plans are part of that assessment, and we've determined whether or not a period of time of O&M offset is warranted. In these particular cases, we did just determine for a period of time until the cost, the customer base can grow large enough to pay for the O&M costs of the project. So that's why these trust funds were part of the settlements to defray for a period of time those O&M
And
costs.
I understand, and I appreciate that. It would be helpful if you would provide us with the department's estimate of what the increasing cost might be each year. It doesn't have to be precise, maybe a general statement, so that we have it available as we're encouraging the members of Congress to join us in trying to reach support for these settlement agreements. And so I want to thank everybody for being here and taking the time to join us today. And these agreements, I have a long-term understanding of how they work and how much incredible effort has been put in to try to put them together. I really do, and I really appreciate all of you being here to try to help move this forward. And with that, I thank all of you for your testimony and the members for the questions. The members of the committee may have some additional questions for the witnesses, and we'll ask you to respond to these in writing. Under Committee Rule 3, members of the committee must submit questions to the subcommittee clerk by 5 p.m. Eastern on Friday, July 26th. The hearing record will be held open for 10 business days for these responses. Without objection, the subcommittee stands adjourned.